Welcome to the Deep Dive. Today we're exploring a really fundamental question in contract law, one that honestly can feel a bit heartbreaking sometimes. When does a kind promise, one given freely, maybe out of sympathy, actually become something legally enforceable? When can you sue on it?
It's a classic tension.
Exactly. And we're going to dig into that using a fascinating case from the 1800s, Kirksey v. Kirksey. It really highlights this conflict between, let's say, the cold, hard rules of contract and, well, basic fairness. This
Yeah.
case is perfect for showing you exactly where that line gets drawn between just a nice gesture and a promise that holds up in court.
And the way we'll analyze it gives you really the essential toolkit for spotting this issue. We'll start with the old school rule, the
Yeah.
strict bargain idea. Then we'll apply that rule step by step using the Fire Act method on Kirksey. And then we pivot to the modern view, the one that actually came about partly because of the result in Kirksey, that's promissory estoppel law. So by the end, you'll have both angles covered for analyzing these kinds of promises.
Okay, let's lay the groundwork first before we jump into the case. If I just promise out of the blue, hey, I'll give you $100 tomorrow because I feel bad for you, and then I don't, you can't really sue me.
Right.
So what's the missing piece? What's that fundamental legal requirement needed to make my promise stick?
That crucial piece is consideration. It's the absolute bedrock. The general rule historically is super strict. For a promise to be legally binding, it must be supported by consideration. And consideration, at its heart, means a bargain for exchange.
Bargain for exchange. Okay, what does that mean in plain English? Does it have to be like a haggle in a market?
Not necessarily a haggle, but it does mean an exchange. The promise from one person has to induce the other person to do something or not do something they have a right to do. That's the detriment. And crucially, that detriment, that action or forbearance, must be what induced the promise in the first place. It's a two-way street. The promise causes the detriment causes the promise.
So it's got to be mutual. My promise for your action for my promise.
Precisely. If a promise is just made out of, kindness, sympathy, affection, what the law calls a gratuitous promise, basically a gift promise, it lacks that mutual inducement. It lacks consideration. So historically, unenforceable.
Okay, that makes sense. It has to be an explicit, if you do this, then I promise that kind of structure. So let's take that strict 19th century bargain idea and really test it against the facts of Kirksey v. Kirksey. This was Alabama Supreme Court, 1845. You said it's a classic example of a court sticking rigidly to that formula, maybe even when it felt wrong.
That's exactly right. It's often seen as a somewhat harsh application of the rule.
Okay, let's analyze Kirksey v. Kirksey. First, lay out the legally dispositive facts for us. What actually happened here? Who were these people?
All right. So the plaintiff, her name was Antiloco Kirksey, was the widow of the defendant's brother. She'd recently lost her husband. At the time this all started, she was actually living okay, relatively speaking. She was settled on public land and, importantly, had what's called a lease preference. She intended to secure that lease. So she had a stable place, a path forward.
Okay, so she wasn't destitute at that exact moment. She had prospects.
Right. The defendant, her brother-in-law, lived about 60 or 70 miles away, a fair distance back then. So in 1840, he writes her this letter. He says he feels sorry for her situation, her being widowed. And then he makes the key promise. He says, and this is pretty close to the quote, "If you will come down and see me, I will let you have a place to raise your family, and I have more open land than I can tend."
If you will come down and see me, I will let you have a place.
Sounds like a pretty clear promise tied to an action moving. What did Antiloco do?
She relied on it completely. She abandoned her place on the public land. Crucially, she didn't secure that lease preference, essentially losing that valuable opportunity. She packed up her home, her family, everything, and made that 60-mile move to her brother-in-law's property.
Wow. And did he keep his word initially?
Yes, for a while. He did put her up in a comfortable house, gave her some land to cultivate. Things were okay for about 2 years.
Okay. So far, so good. But obviously something went wrong. It did. After 2 years, he told her she had to move out of the comfortable house and into basically a rough cabin in the woods. And then, not long after that, he told her she had to leave his property entirely. Kicked her out.
Oh, man. So she gave up her secure situation, moved 60 miles based on his promise, lived there 2 years, and then was just out on her ear. That's rough. And what was the core legal issue the court had to decide?
The central issue was this. Did Antiloco's act of abandoning her home, losing her lease preference, and moving 60 miles count as legally sufficient consideration to make her brother-in-law's promise of a place to live enforceable? Or was her move just a necessary condition she had to fulfill to receive what was intended purely as a gift?
Condition versus consideration. That's the key legal fight here. Okay, and what rule did the court apply? You mentioned the strict 19th century view.
They applied that strict bargain theory of consideration exactly. The rule they went with was that a promise intended as a mere gratuity. A gift doesn't magically become a binding contract just because the person receiving the gift incurred some loss or inconvenience, some detriment in the process of accepting it.
Even a huge inconvenience like moving 60 miles and losing land rights. How did the court justify that? What was their analysis?
Their analysis focused almost entirely on the brother-in-law's apparent motive. They looked at the letter, saw the language about pity for her situation, and concluded his promise stemmed from kindness and generosity. It was gratuitous. Therefore, they reasoned, her act of moving wasn't the price he bargained for in exchange for his promise. It was simply a necessary condition she had to meet for him to give her the gift of housing.
That distinction feels a bit thin, given what she gave up.
Yeah.
Can you clarify that condition versus price idea a bit more, like that example you mentioned earlier?
Sure, think of it like this. If I say, I feel generous, I'll give you $100 if you walk across the street to my office to get it. My primary motive is generosity. You walking across the street isn't something I particularly need or want you to do. It's just how you collect the gift. That's a condition. But if I say, I need this package delivered across the street right now, I'll give you $100 if you take it over there, then your act of walking across the street is the price I'm paying for my promise. That's consideration.
Okay, got it. So the Kirksey court saw the brother-in-law as just being charitable, and her moving was just the way she could accept his charity. He didn't personally benefit from her move itself.
Exactly. Since he received no real benefit and his motive seemed charitable, the court found no bargain for exchange, no consideration.
And the conclusion was the final judgment.
The conclusion was that the lower court's verdict in favor of Antilico was reversed. The Alabama Supreme Court held that the facts simply couldn't support a breach of contract claim because the promise lacked consideration under that strict standard. She lost.
Wow. That just feels fundamentally unfair. She gives up a real, tangible property interest, uproots her family, travels a long way, all based on his word, and the law says, too bad it was just a gift. That massive loss she suffered, surely that should count for something.
You're voicing the exact discomfort that many people feel with this ruling, and it highlights the limitations, maybe even the injustice, of applying the bargain theory so rigidly. And importantly, one judge on that court felt the same way. Justice Orman wrote a very brief but powerful dissent.
Ah, the dissent. What did Justice Orman say? Did he see it differently?
He did. It was just one sentence, but it's incredibly significant. He basically said his feeling was that the loss and inconvenience Antilico suffered, especially abandoning her home and moving 60 miles based on the promise, was enough. He thought it is a sufficient consideration to make the promise enforceable. He focused squarely on her reliance, her detriment, her loss of opportunity, shifting the focus away from the brother-in-law's motive and onto the impact on her.
So the dissent zeroed in on the reliance, what she did because of the promise, and what she lost. Now, you said earlier this dissent became really important later on. It lost the battle in 1845, but somehow won the war. How did that happen? What's the modern doctrine that picks up on this idea?
That's a great way to put it. The dissent's focus on detrimental reliance became the seed for what we now call the doctrine of promissory estoppel. Promissory estoppel is essentially an equitable safety net. It allows courts to enforce certain promises even if they lack formal consideration under the strict bargain test, but only under specific conditions.
Okay, so it's like an exception to the rule. What are the conditions? When does it apply?
There are generally three key elements you need for promissory estoppel. One, the person making the promise must have reasonably expected that their promise would cause the other person to act or refrain from acting. It has to be foreseeable reliance. Two, the person relying on the promise must have actually relied on the promise and suffered a real detriment as a result, like Antilico giving up her land preference and moving. And three, the court must find that injustice can only be avoided by enforcing the promise. It's fundamentally about fairness in situations where someone has been significantly harmed by relying on a promise.
And Antilico's situation seems like a perfect example for that, right? He must have known she'd rely on his offer.
Absolutely. It's hard to imagine he wouldn't foresee that telling a widow to abandon her home and move 60 miles would lead to reliance. Her reliance was reasonable, foreseeable, and resulted in significant harm when he broke his word. That's why Kirksey, despite being a loss for Antilico under the old rule, is now a cornerstone case used to teach promissory estoppel. It shows exactly the kind of injustice the modern doctrine aims to prevent.
Hey, this is incredibly helpful. We have the old, strict bargain rule, and then this modern, reliance-based safety net. Let's synthesize this for everyone listening. If you're faced with a situation, maybe on an exam, maybe in life, where someone's arguing a promise should be enforced, what's the practical step-by-step way to analyze it? What's the checklist?
Okay, here's the diagnostic checklist. You absolutely must go through these steps in order. Start with the traditional rule first. Step 1, the bargain test. This is pure classical consideration. Ask, was there an explicit bargain for exchange here? Did the person making the promise seek the specific action or forbearance from the other person in return for making that promise? Was it truly a reciprocal deal? If the answer is yes, if you find that mutual inducement, then you have consideration. Full stop. The promise is enforceable as a standard contract. You don't need to go further.
Okay, start with the bargain. If yes, you're done. If no.
Right. If you conclude there wasn't a bargain, move to step 2, the gratuitous promise test. Ask. Okay, so if it wasn't a bargain, was it clearly intended as a gift? And crucially, was the detriment the promisee suffered simply a necessary condition for receiving that gift rather than the price? If it looks like a gift, and the action was just incidental to receiving it, like Antilico moving was seen by the Kirksey majority, then the promise fails the classical consideration test, no contract under the old rules.
So steps 1 and 2 cover the classical analysis. If the promise fails both, then we look at reliance.
Exactly. Only if you fail under classical contract theory do you move to step 3, the reliance test, promissory estoppel. Now you ask the equity questions. Did the promisor make a clear promise that they should have reasonably foreseen would induce action or forbearance? Did the promisee actually rely on that promise to their significant detriment, like giving up property, taking on debt, moving across the country? And finally, is enforcing the promise the only way to avoid injustice? If you can answer yes to these reliance-based questions, then even without consideration, a modern court can enforce the promise under promissory estoppel.
That framework really clarifies things. You tackle the bargain first and the gift condition distinction, and only then bring in reliance as the potential savior.
Precisely. It ensures you address both the legal claim, contract based on bargain, and the equitable claim, fairness based on reliance.
We've really seen how that one act in Antilico, moving 60 miles, could be viewed so differently. First, just a condition to get a gift. Later, the very symbol of detrimental reliance. So for everyone listening, the big takeaway seems to be, when you hear a promise, or maybe even make one, pause and think like a lawyer for a second. Use that checklist in your head. Ask, is this actually a trade, a bargain? Am I giving something up specifically for this promise? Or is it more like a generous offer where my actions are just incidental? Knowing that difference is critical.
It really is. And maybe a final thought to chew on. This whole evolution from Kirksey to promissory estoppel raises a bigger question about what the law should prioritize. How much weight should we give to the formal structure of a bargain versus the maybe messier realities of fairness and reliance? Does making it easier to enforce promises based on reliance, like we do today, risk turning every casual assurance into a potential lawsuit? Or is it just the necessary cost of preventing outcomes like Antilico's? Something to definitely mull over.